I wish to acknowledge the Ngunnawal people as traditional custodians of the land we're meeting on and recognise any other people or families with connection to the lands of the ACT and region. I wish to acknowledge and respect their continuing culture and the contribution they make to the life of this city and this region. I'd also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are listening today. Welcome to Safety Spotlight, a podcast from WorkSafe ACT. My name's Lish Fejer, and each episode we focus on a particular area of workplace health and safety. This episode is all around work health and safety prosecutions. Are they a deterrent? Do they provide some levels of accountability for organisations? What's the financial impact? Is that also the deterrent? And does public awareness raise the profile of this so that we can get more conversations to primarily make every workplace a safe workplace? Joining us in front of the microphones, as always, Jacqui Agius, Work Health and Safety Commissioner here of WorkSafe ACT. Hi, Jacqui.
Objection. Oh, sorry, Lish. I was actually remembering a story when I first started practicing as a criminal defence lawyer, and the prosecutor stood up and started giving the introduction, and I was so excited. I think that was like my second or third hearing, and I, in the middle of the prosecution's introduction to the case, I jumped up and said objection. And very quickly sat down and apologised, felt like an absolute fool. But anyway, there we go.
It passed on, but equally showing the expertise, both from the legal perspective, but our Commissioner here in the ACT, also bringing the expertise, Simon Nicholson, who's the Work Health and Safety Prosecutor with the Queensland Government. Simon, thanks for joining us.
Thank you. Thanks for having me.
Now, both of you have so much experience in this particular topic. Can I just ask Simon, first of all, what is your role primarily?
So I lead the Independent Work Health Safety Prosecutor's Office in Queensland, which is the only one of its type in Australia. We are separate from the regulator and we perform a similar function to that of the DPP. We receive briefs of evidence to assess against the Director of Public Prosecution's guidelines, and we commence criminal cases in the Magistrates and District Court. We prosecute on behalf of Workplace Health and Safety Queensland, along with the resources regulator, Resources Safety and Health Queensland.
How does it work in the rest of Australia?
In a former life, I headed up a team in the DPP in Tasmania, where we would receive referrals in a similar way. But in my experience, it would seem around Australia, the DPP handles these kind of cases, or the private bar or a private counsel.
In the ACT, Jacqui?
In the ACT, WorkSafe ACT will conduct the investigation, and we refer those matters to the DPP. In 2022, Mari Boland, who is currently the CEO of Safe Work Australia, conducted a review in relation to prosecutions in the ACT, and she recommended a hybrid model for us in the ACT. And at WorkSafe ACT, we're working hopefully to encourage the government to pursue that hybrid model for us.
What triggers an investigation leading to prosecution? Because not every breach ends in a prosecution.
It's probably something that Jacqui could answer better. But in terms of the prosecution role, there are a number of notifiable incidents under the Work Health Safety Act. They need to be reported to the regulator, and then depending on the severity of the incident, so whether it involves a fatality or a very serious injury, it's those more complex cases that are referred for prosecution. But equally, we do licensing breaches, we do matters involving more risk-based matters where no incident occurs, but there's an identifiable breach of, or allegation of a breach of the Work Health Safety Act. So it's within the regulator's purveyance as to what they refer to us, but usually it's the more serious notifiable incidents.
And I'm glad, Simon, that you mentioned risk-based prosecutions, because I'm hoping later in the discussion that we can get really into the depth of what risk-based prosecutions are. For me, the decision to prosecute is based on three things. Firstly, that there being sufficient evidence available to take the matter before a court. that there is a reasonable success of a successful conviction. We don't want to waste resourcing or the court's time and money to proceed in a prosecution where we know we don't have the evidence to have a successful conviction. And the third is the public interest test. And the public interest test can include considerations like the seriousness of the alleged offence, any mitigating circumstances, the duty holder's characteristics such as prior history or if they are a repeat offender, and also the degree of culpability of the alleged offender.
Okay, I don't come from a legal background, and you clearly bring all of that expertise. How often do you find in prosecutions that people, it's a very unfamiliar space for people? How much education do you have to do around that initially?
I think it's frequent. And it's a very important part of my role to ensure that affected workers and next of kin are involved in the process, insofar as being educated about what it means to go to court, what it means for a criminal case to be conducted about work health and safety. It's different to the more run-of-the-mill offending that you might read in the newspaper or hear on the radio or watch on TV. They're unique kinds of criminal cases. They are difficult to litigate. They involve really big concepts of both law and of safe work procedures, expert evidence, stuff like that. So a very important part of my role is to educate not only those very important stakeholders, but also the community through things like my annual report, the court reports on our website, to ensure that people know what we do, how we do it, what's involved, because it is critical.
Do you have a similar threshold in Queensland that Jacqui explained?
We do. So prima facie case, so that means, and that's usually where an incident occurs, that is evidence of a prima facie breach. A reasonable prospect of conviction, so is there enough evidence? And that's a very important thing to remember, is that there needs to be evidence that can be put before a court that is relevant, that it's admissible, and that it's persuasive, so that, as Jacqui said, there is a reasonable prospect of either a judge and a jury in, say, an industrial manslaughter case, finding the defendant guilty beyond a reasonable doubt, or a magistrate being satisfied to the same standard beyond reasonable doubt. And in relation to the public interest, it's often a very interesting concept to think about. Jacqui hit the nail on the head in relation to some of the key considerations. Other things we think about include... I think Jacqui might have mentioned this, prevalence. Is it a matter of major public concern? What's the likely outcome? As we know in this space, it's usually a fine. There are very few offences that would result in a term of imprisonment. And whether there is a cost factor. These can be very expensive matters to litigate. And what is the cost of doing so? But usually where there is a prima facie case and a reasonable prospect of conviction, it will be in the public interest to proceed.
I think you raised a really good point in relation to working with those families or stakeholders, because a massive part of that from a regulatory perspective is that management of expectations. And our matters are very different to your standard criminal offence matter. So when the police charge somebody with an offence for, let's say, a drink driving offence, then there is a prosecutor who is prosecuting a person on behalf of the police. In relation to work health and safety matters, there is a worker or a group of workers, unless it's a risk-based prosecution. But the prosecution are prosecuting the business or the PCB on behalf of WorkSafe. And that can at times be a very challenging thing to explain to those workers and those stakeholders, because the expectation for the worker, the group of workers, their friends or their family is for them to get justice. But in the case of work health and safety prosecutions, that is something that often people are very disappointed with.
Why is that, Jacqui?
Because the prosecution is WorkSafe against, not the worker against the PCBU.
And do they feel that they're not being represented?
They can at times.
Individuals?
They can at times feel as though they're not being represented. They do get the opportunity to provide a victim impact statement, and that is where they have the opportunity to speak. But because it's not directly them against their employer or their previous employer, they sometimes feel as though they're outside of the process. And so there's a lot of explaining and education in relation to those stakeholders around what it means for WorkSafe to prosecute a workplace.
It's a really good point, Jacqui, and it's a real challenge for an affected worker or a next of kin who has lost a loved one to accept that we are not their lawyers. Mm-hmm. In my role, I'm a lawyer for the state. And sometimes in applying the director's guidelines and making the very critical decisions that I need to in terms of how a case is prosecuted, they might be inconsistent with the family's expectations. But managing expectations is so important. We have, in relation to fatality cases, a support service that has specialised workers to assist with the communication with families. And look, we all know that lawyers talk in another language. You add on top of that the really big concepts that we deal with in terms of safe systems of work, engineering schematics, expert evidence about noxious gases. It's really overwhelming for a family or an affected worker to understand. So it's key to ensure that they understand as much as we can convey an understanding what we're doing.
It's so that process, Jacqui, here in the ACT, you've described some of the thresholds, but what is the step-by-step process, if it's not going into too much?
No. So work health and safety investigations can be complex because they can involve, and in most instances will involve, a number of different legislation laws, a number of different laws and a number of different supporting documents such as, things like codes of practice, Australian standards, and all of these come into being able to prove the work health and safety breach. Our investigation team are aware of the matters that are coming in to our office through our inspectorate. So if one of our inspectors or a group of our inspectors is concerned about a matter that a workplace that they've been to, they will engage one of our investigators immediately to look into the case. And our investigators will go into the workplace and start either records of conversations or records of interviews. They will seize materials or 155 documents. So Section 155 allows WorkSafe inspectors to obtain documents from work in order to assess what the breaches are. Often in work health and safety matters, you'll also need to engage an expert because at times you're dealing with some really complicated matters such as, concrete pours that have a boom, and you want to assess if it's an issue with the boom, if it's operating properly, if it's a crane that drops a load, you'll need to determine what it was about the weighting or the way the load was lifted that may have caused it to drop. You'll have engineering issues. You can have trenches fall in, and we've seen some dreadful cases in Victoria where there have been trench collapses where workers have been killed. And so all of those things need to be taken into consideration during the investigation phase. Initially, our inspectors will recommend to our case management panel that an investigation start. And they will provide a paper to our case management panel. Our case management panel will determine whether or not to recommend the case to me to approve an investigation proceeding. So it is internally, there's a whole lot of things happening behind the scenes. And, that can confuse people, of course. It's not, in the case of a criminal charge under the Crimes Act. For instance, if someone commits an aggravated burglary and they're apprehended immediately, they're taken before the court straight away. But in the case of work health and safety matters, it can take a number of years before we get to the court.
Because you're in all of those investigations, those initial investigations, before you've said we will prosecute, you're trying to determine if there has been a breach of that act.
That's right. And that, insofar as my independent role, that's entirely the role of the regulator to go out and investigate, obtain evidence and make the decision to refer. It takes a long time. We know there's some discussion about the statute of limitations from that case in the High Court. Discussions in there about 2-year limitation periods and so forth.
And I have to say, Simon, I'm pretty jealous with what you have in Queensland in relation to the statute of limitations.
So in our jurisdiction, it is when knowledge of an offence comes to my notice rather than to the regulator. So that might be the difference between what occurred in New South Wales versus the state of affairs in Queensland. There's a bit of discussion, though, about why these cases take some time to investigate. They are complex, they are difficult, they require the sourcing of a multitude of evidence. Some of our briefs of evidence come to 7, 8, 9, 10,000 pages of material to consider. That takes time not only to gather, but also for our skilled lawyers to assess and provide a recommendation. So there needs to be those longer time frames to consider. And again, if we return back to our earlier discussion about managing expectations, I think it's important to manage the expectations not only of the interested persons, the affected workers and next of kin, but also the community to understand why it takes that time. So for an incident that may have occurred in 2022 only to then be commenced in 2024 and then take until 2026 for a judgment.
And that wouldn't happen in the ACT. The reason that it happens in Queensland and why I'm envious of Simon's model is that in Queensland, the statute of limitations, which is 2 years under the model laws, begins when the brief of evidence is referred to the prosecutor, so in that instance to Simon.
After all that gathering of evidence and background.
But for us in the ACT, the 2-year statute of limitation begins as soon as we become aware of the incident or the breach.
Which affects prosecutions in the ACT where you are limited by?
It can, in that we need to get a matter to the court, the industrial court, within 2 years of the incident occurring, whereas the model in Queensland allows Simon a little bit more time to get that matter before the court. And at times, that tightness of that statute of limitations may impact on us being able to prosecute a matter, particularly if we've engaged experts, but then we need to engage more experts because of what that expert has told us, and so we can end up in difficult situations because of that statute of limitations.
And that might, in terms of what Jacqui mentions about experts, when we get on to talking about psychosocial matters, that may be a challenge.
Yeah. Well, we might look at risk-based prosecutions first. So how can regulators reframe WHS practices through risk-based enforcement? What do you mean by risk-based enforcement, and how does it play out?
Historically, the vast majority of WHS prosecutions in Australia have been initiated in response to an incident resulting in either an injury or death to a worker or another person. However, the wonderful thing about the Model WHS Act is that it puts a focus on primary prevention, reiterating that work health and safety is about preventing workers being harmed at work, workers and others being harmed at work. So a prosecution initiated for a risk-based offence that occurs in circumstances that has not already resulted in a death, injury or illness or actual contact with a hazardous substance or bacterium. So a risk-based prosecution aims to hold a PCBU and individuals accountable for failing to manage a foreseeable risk before the harm occurs.
I'm sure there's case studies to illustrate this, Simon.
Yeah, sure. Look, I was thinking about this in preparation for today, and the most recent examples we can think of, and the easiest probably, are the cases involving engineered stone. Mm-hmm. That discussion has come out of that really clear risk being identified in the use of that substance. We know that silicosis has been something that has existed for many, many years, but it materialised when workers started reporting these really serious symptoms of dust-related diseases after working with that particular product. And there have been a few prosecutions coming out of that where the work has been identified as risky. There has not been a materialisation of actual injury because, as we know, much like with asbestos, it takes years or decades for, unfortunately, that kind of dust-related disease to materialise. But there has been one or two prosecutions in Queensland about that. One involved the inappropriate cutting of engineered stone where disposable masks were being used, or simply a rag over the face and a spray bottle being used to spray down the bench as it was being cut. So there was no suppression of the dust, no health monitoring, and the defendant was convicted and fined. In Tasmania, there was also a case involving the use of engineered stone that resulted in a very significant fine. Other risk-based prosecutions, we are still dealing with the failure to manage the risk of exposure to asbestos-containing material. Everything from the commercial removal of asbestos, where it has been undertaken by an unlicensed practitioner, right through to a person spraying a roof, so cleaning a roof in preparation for painting. The roof is old, it contains asbestos-containing material. A high-pressure spray is used, it disperses asbestos-containing material over the neighbouring properties. So those kind of risk-based prosecutions are still coming through. We have had risk-based prosecutions in relation to scaffolding collapse where there's been no injury, but an identified breach has occurred in terms of the safe erection of the scaffolding. We had a recent decision where a number of divers were left at sea after a skipper had to attend to an emergency situation, and in doing so left the dive site and left a number of divers underwater. They came back up wondering where the boat was. They were exposed to an obvious risk to their health and safety. Cranes, there's been some cases involving cranes that have collapsed by not having the right counterweights on them. And electrical safety, that's a big one, where, say, apprentices have held themselves out to hold the right licences and undertaken electrical work that, upon further assessment, there have been live wires or a real exposure to various aspects of electrical safety, which is a very complex area of regulation, but fans that had water leaking into them or cooktops that could have presented a real fire risk. So nothing has actually occurred, but the risk has been identified, and in investigating and prosecuting, hopefully others are deterred from doing that conduct in the future.
Does it work? Because it is preemptive.
It is preemptive.
And you have to choose those cases.
We have to choose
wisely.
Those
I don't want to use that word.
Carefully and wisely, absolutely, because we're all managing under constrained resourcing, and so often it's difficult to run a risk-based prosecution. We're still developing that in the ACT because there has been no harm, and it's really about educating people and our community and our courts and our prosecutors that risk-based prosecutions are just as important as prosecutions after harm has occurred.
With my media hat on, I imagine the talkback line lighting up, or even people listening on a building site saying, "We are not the only ones to be doing this. Why did we get chosen? Why was our incident? Why was our breach the one that was picked out?" When clearly this is a problem across an industry.
We're starting to see wider industry prosecutions nationally. So in Western Australia, for instance, they have charged the Department of Justice in relation to psychosocial hazards in the workplace for prison guards. We've seen some in Victoria where we saw the Court Justice Services prosecuted for psychosocial hazards in the workplace. So we are starting to see, particularly because of the changes in the model laws in relation to psychosocial hazards, much broader industry prosecutions occurring nationally.
Well, in Queensland, we haven't had any completed psychosocial cases yet. They will be coming, I would imagine. In terms of the risk-based one, I guess returning to electrical safety, that's the big one. In terms of addressing a real palpable risk of someone undertaking unsafe electrical work that has a real chance of electrocuting someone, even years down the track. If there's a successful case prosecuted and a fine is imposed that deters others from doing it, that is a great outcome.
Yeah, and you find it works that as a deterrent.
I wouldn't be comfortable in saying that I find it works, but certainly courts are becoming better educated about the risks arising from this kind of failure of complying with health and safety laws. Therefore, they are sending more messages out there, and hopefully they get through to those who need to hear it.
And people's awareness, I imagine,
That's right.
too, for the public awareness of what to ask for, what to, even that knowledge.
What we're seeing nationally is some higher fines being imposed by courts. We've seen that particularly in the ACT. So last year there were 2 significant prosecutions before the ACT Industrial Court. The court imposed fine for MME was $375,000 after the discount for a plea of guilty, and in relation to TCCS it was the same. MME is the PCBU metal manufacturers. And so we're seeing courts now take a stronger approach in first offence incidents in relation to WHS breaches, and I'm very heartened by that approach, as I'm sure Simon is as well.
Yeah. We've spoken about psychosocial injury, and you said, Simon, that you expect to see more prosecutions around this.
Yes.
We've spoken about it a lot on the podcast. Still this sort of growing understanding. What are you seeing in terms of prosecution and the potential for more prosecutions, and how are you going to find evidence for...
Yeah,
that's the how that
that
present
may
the
be
challenge.
one for the regulator.
Yeah.
But of course, with Simon's expertise and making some additional comments, but we know that psychosocial hazards are more complex and less tangible than physical hazards. And so identifying, assessing, managing and enforcing the standards for psychosocial risks is challenging, and it makes those investigations challenging because what we are looking at is the system of work in the workplace. That's another element, or can be another element of confusion for workers who are witnesses for us, because let's take, for an example, a workplace bullying matter, for instance. When we talk about a risk-based prosecution, we won't necessarily be leading evidence or putting evidence before the court that bullying occurred in the workplace. What we will be looking at is whether or not there was a system in place in the workplace to protect workers from that bullying hazard or that risk of bullying. And that can be difficult for people to understand, because they want to be able to tell their story about what happened to them in their workplace. And WHS prosecutions just doesn't allow for that to occur. But with a risk-based prosecution in the space of a psychosocial hazard, the laws have changed to highlight the importance of that prevention. In 2018, Murray Boland conducted a review into the WHS model laws, and that report was released in 2019. So reforms that came out of the Murray Boland review has led to amendments in model WHS legislation to include the requirement to identify and manage psychosocial hazards in the workplace. But yeah, Simon, what's your perspective?
Yeah, sure. Look, as we know, managing psychological health has always been a duty under the Work Health and Safety Act. So the definition of health includes physical and psychological health. But as Jacqui mentioned, the review prompted a greater reform in this area, and Queensland was the first state to publish a code of practice in relation to psychosocial hazard and risk. A colleague in this space explained it to me as looking at a dirty fishbowl. So a dirty fishbowl where there are unsafe work practices, where we're making the environment unsafe psychosocially for workers to work in. And what we're looking at is framing allegations about controls that should have been in place to make the fishbowl clean. And in framing those allegations, in looking at the evidence we need, in thinking about how a case will be framed, it will be challenging because we're thinking about methods and systems that produce an adverse psychological result or a risk of that. It's not just the systems of work that we can see, an unguarded piece of plant, an operator of a forklift being unlicensed, or someone not wearing a fall arrest device. It's something more deeper and broader than that. So it's a fascinating area of hazard and risk mitigation. There will be challenges. We saw recently in New South Wales where there was a discontinuance of a prosecution involving a state entity regarding systems in place to deal with complaints, concerns and grievances. And notwithstanding the trial went for a number of weeks, it did not continue. You can read about it in the judgment, but certainly that gives you an indication of some of the challenges in this space. It will be expert evidence heavy. It will be a different kind of way that witnesses will explain about how work has affected them. I'm probably using the wrong language here, but it will be a lot of it feels like law. It will be how they felt about a system of work and how it affected.
We're not talking about the vibe, are we, Simon?
We're not talking about the vibe at all.
The vibe.
But
it does sound subjective, though, because it's a person's experience.
That's right.
In that workplace, and what tools have you got to clean the fishbowl?
That's right. And what tools are reasonably practically available? Because notwithstanding the fact that these are very serious cases, they still need to be proven beyond a reasonable doubt. And in terms of what you've identified there, in terms of the tools and the evidence there, it will be expert heavy. It will be the subjective experience of the worker, an assessment of the risk, and then evidence about what could be done.
But we know with, when physical hazards started to be identified in workplaces, there was very much a view of how do we do this? How do we get safety right when it comes to physical hazards? And you're absolutely right in saying the requirement to risk manage psychosocial hazards has always been there. However, we haven't always done it, and we've focused on those physical hazards because you can see them.
That's right.
Now, you mention slip, trips and falls, and everyone knows what it is. Or you mention electrical hazards and people understand that you can't have cords going across any workplace where people can trip over them, or people know they have to test and tag, and so those things have become so common, and that's where we need to get with psychosocial hazards, where they become so common that best practice controls are adequate and everybody knows how to use them and what they are. And we will get there, I'm sure we will.
Best practice controls more than just a QR code in the back of a toilet door saying if you feel unsafe.
That's right.
Best practice controls are so important in this space. One of the differences nationally in this space is both Queensland and the ACT, and of course Commonwealth as well have the hierarchy of controls built into the psychosocial hazard code of practice, whereas some jurisdictions do not use that model. And until we get into the practice of implementing the risk management system in relation to psychosocial hazards, it's going to take us some time to settle where we should be in that space.
Have we got any examples of cases or interventions around psychosocial prosecutions in ACT or Queensland? Or
Not any finalised cases yet. Jacqui mentioned the one that's been commenced in Western Australia. It's on the radar of Safe Work New South Wales, but I can't give any examples.
Any breaches or warnings? Or
I can say that in the ACT, we haven't prosecuted for psychosocial hazards as yet, but I can say that our investigation team is currently investigating 34 matters, and I would say that at least 5 of those are related to psychosocial hazards. So we may in the future see some of those cases before the industrial court in the ACT.
Let's keep on case studies, because I wonder what the trends are around work health and safety prosecutions. What are you seeing?
Yeah, well, look, I've been doing this now I've been a lawyer now scarily for 20 years. I've been working the criminal regulatory space for about 15 of those, and in work health and safety for a similar period of time. And the consistent kinds of things that come across my desk include fall from height, unlicensed or young or inexperienced workers using very dangerous pieces of plant like forklifts, and unguarded plant. Another big one is failure to induct or monitor or enforce compliance with safe systems of work, particularly again with young workers. Jacqui and I spoke at a conference recently where she spoke about some of the regulatory focus here involving making sure young workers are safe at work. And tragically, some of the saddest cases I see involve young workers or inexperienced workers using these very dangerous pieces of plant, or not doing the simple thing of using a fall arrest device or working at height on an old roof and falling through a skylight. Those are some of the things that sadly I see time and again.
You mentioned young workers, Simon, and last year there was a successful prosecution in the ACT Magistrates Court involving a young worker, and the incident was in an electrical manufacturing premises, and they had moved premises. And when I'm not sure if people can kind of imagine racking in these manufacturing premises that have big reels of electrical cord on them. And when you move a premises and you're installing racking, you must have that racking installed by a competent person. And in this instance, what had occurred was that some of the racking had been installed by a competent person, but the people installing the racking didn't have time to finish it all on one day. There was some racking that was left on the ground, and what had occurred was that a young person had needed to wind up some of the cord onto the winding machine. The racking contained about 150 tonnes of wiring and had not been bolted down and fell on top of this young worker. Now, had there not been a void in between the reeling machine and the racking, that worker would likely have died. They sustained really serious injuries, and the fine, starting fine, as I'd said earlier, was $500,000, reduced to $425,000. Vulnerable worker, not being supervised, really, really sad incident.
How much does the she'll be right attitude play into all of these prosecutions, like all of those fall from heights, no safeguarding, this sort of complacency?
Yeah, it's interesting because there have been so many cases involving these simple failures that you would think the message would get through to industry and or workers and all those who engage in these dangerous ways of doing work, that it is a simple thing to address. And so Yeah, it's interesting that there are still cases that could have been avoided if someone had just clicked on, or if there had been 5 minutes more worth of induction, or if there had a simple $500 guard been put on a very dangerous saw before someone operated it and lost a hand.
We've done a podcast around cold workers in particular, and the communication and the need for those inductions or onboarding in culturally appropriate language and meeting them where they are. Do you see any cases around that?
There's been a few that have come across my desk, and it's really highlighted to me the importance of ensuring that these systems of work, which may be great and may function in a really great way, function for everyone and function in a way that people from those different and diverse communities can understand, can engage with. It may be different to a work practice they may have engaged in living elsewhere. It's so important that these safe systems are available for everyone to engage in.
Key takeaways from WHS Prosecutions, both the Queensland perspective and Jacqui, the ACT perspective.
In the ACT, we are seeing more matters being prosecuted for WHS breaches in the industrial court. And what I want to say about that is that we will continue to hold duty holders to account in the ACT. But what I would dearly love more than anything is that there were no prosecutions for WHS breaches in the ACT, because that would tell me we have safe workplaces in the ACT, and that's what I want to see.
Yeah, I think it's a good point, even though it would put me out of a job. But the last thing that a business wants to see, the last thing that a community member wants to see, the last thing that someone waiting for a loved one to come home from work wants to hear about is a death of a worker, a serious injury to someone simply going to work. So the best outcome, of course, for everyone would be if there were no work health safety prosecutions. But in terms of the very important role that prosecuting has in the enforcement and compliance regime, Queensland's Independent Work Health Safety Office has been really successful since it was established in 2019. We have a lot of successful finalised cases, and the sentences reflect that courts are being better educated by skilled and experienced prosecutors. And yes, I'm doing a bit of a shout out to my very skilled and able staff. And it's also reflective that investigations are becoming more comprehensive, skilled. The legal advice that I receive is becoming very much well-reasoned and accurate, which is meaning that there is accuracy in pleadings and particulars that squarely put a defendant on notice of what it is the prosecution is alleging. We, of course, abide by the Director's guidelines of only firmly and fairly prosecuting a case before the court. And an aspect of doing that is ensuring that the magistrate or the judge is well informed about all the circumstances of the case so that they can arrive at that very proper result in their sentence. So in terms of our experience, the Queensland model, I think, is a really good one. It ensures that an independent prosecution decision is made. It ensures that there is a skilled set of lawyers dealing with this really critical area of regulation. And the results really speak for themselves. But of course, the best results would be if there was no one who was unsafe at work or who was injured or lost their life.
Absolutely, because everyone deserves to go home safe.
The defendant in all of these prosecutions, is it always the PCBU?
Not always. The usual defendant will be a corporation or a business or a partnership, say, or some other corporate form of doing business. But there will be prosecutions of directors for failing to exercise due diligence. There will be prosecutions of workers. There is a duty under the Model Work Health Safety Act for a worker to ensure that their acts or omissions do not expose another person to a risk of death or serious injury, so they need to take reasonable care in ensuring that. So if you have a look on our website, if you have a look at our annual reports, you'll see that certainly in Queensland there is a mix of prosecuting. Usually it will be a corporate defendant, but there have been a number of individuals, workers, directors also prosecuted for failures against the law.
Are there any standout achievements where you've prosecuted and it's had the desired outcome in terms of raising the profile of a particular safety issue?
I think that's a good question. I always come back to Queensland's inactive industrial manslaughter laws in the model legislation because it was the first jurisdiction to do so. There have been 3 successful cases. They've all involved a type of mobile plant, and it shows that where negligence to that really high standard can be proven, that these cases do result in high fines, potential jail time. And we know that these cases really are the jumping point for further discussion about how work health and safety is prosecuted. We saw recently the decision from Victoria where there was a workplace manslaughter case. The defendant pleaded guilty. They were fined $1.3 million. It went on appeal. The fine was increased to $3 million. And if you have a read of that judgment, you'll see the judges elevating the importance of ensuring that even short bursts of inattention or non-compliance or working unsafely should be avoided. There's some really good messaging in there about what the courts are going to start looking at in terms of industrial manslaughter and serious injury cases. So I always come back to industrial manslaughter. It's something that Queensland led the way in. There are not that many cases of it, but they do have an impact when they're commenced and resolved.
So key takeaways for business here. What are the key messages for business?
I think one of them, Lish, really needs to be that prevention is the best model when it comes to work health and safety compliance. Don't wait until an incident occurs before you act, because work health and safety legislation requires you to be preventative and not reactive.
I think that's right. It is so important to comply with health and safety duties. Jacqui's hit the nail on the head in terms of ensuring that everyone complies with their work health and safety duties under the Act. Yes, there is a lot of compliance out there that is expected and it's necessary. And we spoke about that in terms of the psychosocial aspect and the development of the law there. The key takeaways for businesses would be if you comply so far as is reasonably practicable, or you eliminate those very easy hazards and risks, you will not end up in a potentially protracted piece of litigation with the potential for a criminal penalty.
Mm. And some may be, as you say, plant guards. Some may be what feels like a box-ticking exercise of saying, I have put those controls in place. But you have to have those, as we're hearing, the complexities of bringing a case to prosecution is not about the individual necessarily, but about those controls. I've learnt today around the complexities of prosecuting around work health and safety. Anything else you wanted to add, Simon? Anything you wanted to add? Are you closing remarks?
I mentioned before just about it'll be interesting to see where what influence that workplace manslaughter case has on the way in which courts assess penalty and so forth in that space. It'll be interesting to see what happens in New South Wales with the re-establishment of the industrial court. We know that they publish a lot of judgments that provide a lot of insight into sentencing in that jurisdiction, and it's often useful for practitioners in this space to reflect on what's happening there. Again, another subscriber to the model legislation. And psychosocial cases. It's an area of safety that will develop, of safety law that will develop over the next 20 or so years, and we can all think about the key landmark cases in the space that Jacqui and I deal with, and regulators and prosecutors around Australia. We've got those key cases that we always go to involving physical injury, involving easily identifiable risk. It will be fascinating to see how the law develops in terms of these psychosocial hazards and risks over the next 20 years or so.
Yeah.
Yeah, and in relation to psychosocial hazards and prosecutions, it'll be interesting to see what happens with the statute of limitations because, as we know, with psychological injuries, it can be a long time before they come out or before we know that there's an impact. The statute of limitations in relation to psychosocial hazards may not be long enough, and we might need to absolutely consider whether that statute of limitation is long enough.
Fascinating discussion. Thank you both so much.
Thank you.
Simon Nicholson, Work Health Safety Prosecutor with Queensland, and Jacqui Agius here in the ACT, our Commissioner with WorkSafe ACT. Thanks so much for joining us. This has been the Safety Spotlight from WorkSafe ACT. It's been great to have your company. Stay safe.